to Admissibility of Expert Witness Testimony. I'm Lori Cripp-Martin, a certified family law specialist and the vice chair of the Beverly Hills Bar Association's litigation section. And I'm delighted to introduce today's speakers, Eve Brackmann. Eve Brackmann is a senior partner at Munich Wilson Mandela LLP. She serves as lead counsel in jury and bench trials in all California state and federal courts, and she is well known for her effective private arbitration work. Her real estate practice covers high-stakes litigation for casino developers, shopping center owners, mortgage companies, and big box retailers. Her business litigation practice covers disputes in venture partnerships, manufacturing and distributor disputes, contract-related lawsuits, fiduciary duty, unfair competition, defamation, trade secret, and anti-SLAPP lawsuits. Eve also has significant experience with high-stake homeowners association disputes, as well as cannabis-related matters. And now, let's get started. Eve, off to you.
Lori, thank you so much for that amazing introduction. I appreciate that. And I feel really honored and happy to be here today to dive into this really important and evolving topic, admissibility of expert witness testimony. It's been evolving in both federal and California state court for some time now. It's really important. Another thing I love about this topic is that it spans so many different areas of practice. Everywhere that we have a trial, we have the potential for a need for expert witness testimony, and then we have to understand the standards around admissibility of that testimony. That's criminal, civil, all areas of civil, you know, from torts, medical malpractice, things I do like commercial real estate litigation, construction litigation. We even have, I have a high stakes homeowners association matter going on right now in Orange County, and we have experts in that case. It's a lot of different practitioners need to understand admissibility of expert witness testimony. And, you know, some lawyers approach this topic like they're competing in The Bachelor. They want to be the only one that gets the rose, and they want to keep everyone else from getting a rose. And that is one approach. But I do think we have, in our profession, we have a more noble responsibility and noble role than that. We want our clients to have a fair trial, and we want to make sure that the court and the trier of fact are being advised only on reliable expert opinion, not junk science. And so that's really kind of what's at the core of all of this. And if you've ever had to go against and oppose an expert that was clearly just parroting counsel's comments, I think you can understand how it feels to really want to make sure that that kind of thing doesn't get into our trials and doesn't unfairly prejudice our clients. So also for young lawyers, if you're feeling a little AI anxiety lately and that low-key fear that your job might get taken over by a robot that drafts faster and cites better than you, I understand. But here's the thing, AI still cannot think on its feet in a courtroom. And in federal court, yes, Rule 702 and Daubert motions, those challenges are usually briefed and often decided on the papers. Sometimes with a hearing where you can orally argue. But that's largely a paperwork war in federal court. And especially as we'll get to with the Rule 702 amendments, the judge has, as of 2024, become truly a gatekeeper in federal court more than ever. But in California state court, it's different. Yes, we have motions in limine, but I have to say, in my experience, I haven't seen a lot of experts excluded prior to trial. Usually, these objections to expert witness testimony, particularly Sanchez objections, they're hearsay objections, they're evidentiary objections that hit in real time when you're right in front of the jury. And it can even happen, you could get sandbagged. It can happen with little or no warning. So forget motions in limine. This is trial by fire in California state court. And any lawyer that can think fast and speak smart in that setting is irreplaceable, at least as of 2025. So that's the good news. And as the great Mikhail Baryshnikov once said, fundamentals are the building blocks of fun, or something like that. And actually, I have a bonus point question for everyone. What 1980s movie featured Baryshnikov alongside Gregory Hines, one of my favorite movies of all time? And what field of expertise, this is a field of expertise, would those two characters played by Baryshnikov and Hines likely be qualified to testify about? If you can answer in the Q&A, and the first person to get the right answer to both parts of that question or both questions, I will personally, if you would like, buy you a coffee here at Watt Plaza, where our office is in Century City, at Starbucks. We have a Starbucks. Of course, feel free to drop any questions you have in the chat, and I'll answer as many as I can. And if I don't know the answer, I promise, unlike AI, I promise not to hallucinate. I'll just say I don't know. So let's dive in. Let's look at the next slide, please. So this is just sort of a little bit of what we just touched on. And the next slide, please. Yes, so in this session, we'll walk through the legal standards for expert testimony in US courts, California specific issues under People v. Sanchez. That was a 2016 case that changed everything about admissibility of expert witness testimony in California State Court. Challenges and strategies for admissibility, case studies and practical tips. I will share some personal anecdotes if we have time, some personal stories. Trial lawyers love to tell war stories. I promise none of them are open or pending cases. Speaking of which, ethics in expert witness testimony. There's some important things to touch on when it comes to your expert's testimony with regard to ethics and emerging trends. There's some new emerging trends, particularly I mentioned AI, a lot of new ways to present expert testimony that go far beyond the ELMO. Let's see if anyone was able to answer. I don't see the answer to my question. Oh yes, here's the Q&A. Okay, let's see. Yes, Kristen Dale. Oh nope. Yes, that was the first one. Kristen Dale. White Knights was the movie. It was a 1985 movie featuring Gregory Hines and Mikhail Baryshnikov. Dance would absolutely be a topic that they could opine about. They were both experts in the field of dance. I would submit that they could also potentially be experts about Cold War politics. So if you want to know why, watch the movie. I'm sure you can find it on Netflix. Yes, it's who else got it right. Some folks tried to answer, but didn't get it. Rena Pedrosa also got the right answer. So Rena and Kristen, I would, even though Kristen got it first, I would, if you want to come have coffee at Watt Plaza at Starbucks, just email me. We'll set it up. I'll definitely have 10 minutes to have coffee with you if you'd like. All right, so let's go to the next slide, please. This is the learning objectives that we just discussed. By the way, this I provided you a copy of this PowerPoint presentation. The slides are all in the materials. Also in the materials, there's a Rule 702 handout. I'll walk through it with you in a few minutes, a few slides later. And I also, just because I like to be able to watch a CLE without having to take a bunch of notes, and I don't want to watch it again, it's always nice to be able to get the speaker's notes. I have a slide by slide, just bullet point notes for you, as well as some references in the written materials. So there's 3 things in the materials that I provided. I really hope that's helpful. It is kind of a big topic, and we only have, till 1:30. So yeah, and if you have any follow-up questions, please always feel free to email me. My email is in the materials. Okay. So we talked about learning objectives. Let's go to the next slide and let's talk about legal standards for expert testimony in the US. By the way, also speaking of AI, I don't know if you know this, probably the younger lawyers who are tend to be more tech savvy, I think, than us folks who've been practicing since the early 2000s. You can have AI create your slides these days for PowerPoint, just saying. And that goes for creating expert materials as well. Okay, so slide 4, legal standards for expert testimony in the US. Federal Rule of Evidence 702 governs expert testimony, and it was amended in 2023, effective January 1st, 2024. But it was such a big deal that there's even a case that referenced the coming amendment back in 2023, and we'll talk about it a little bit. But it was amended to clarify the court's gatekeeping role. So let's spend a few minutes here because Rule 702, as recently amended, fundamentally reshapes how we think about expert admissibility in federal court. First, the amendment clarifies that it is the proponent's burden to prove by a preponderance of the evidence that expert testimony is admissible. That means judges don't get to punt questions about foundation or methodology to the jury in federal court the way that they do in California court still. The court has to find it, the judge has to find it more likely than not that the expert's testimony meets each requirement of Rule 702 before it gets in front of a jury. And there aren't any weight issues unless and until Rule 702 threshold is met as amended. As I mentioned, we have this handout, FRE 702 handout. What I put in here is sort of a color-coded version of the amendment. So you can see highlighted in blue what was added. And then you can see there was some language that was stricken, and that's redlined. And what was added was at the beginning of the rule that this was original, a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of opinion or otherwise if, and then in the old rule, this if standards or A through D came right after that, but they inserted the proponent demonstrates to the court that it is more likely than not that, and then the standard. So that's where this new standard where the proponent has the burden of proving by preponderance of the evidence that the expert meets these 4 standards. And we'll talk about those 4 standards too. And then in D, the 4th standard, the language was tweaked a bit. Instead of the expert has reliably applied the principles and methods to the facts of the case, super important in itself, they struck expert has reliably applied, and it's the expert's opinion reflects a reliable application of. And so that's a very semantic change. And I think there's a lot of discussion about what that means. There certainly is pages and pages of discussion in the advisory committee notes from 2023 that explain why they made these changes. And so if you're curious about those notes, they're right here in the handout. And then also, I put a few recent applications to the Rule 702 amendment, just some case studies that you might want to look up, some real interesting ones. And the one that I referenced earlier, before the December 2023 amendment took effect, the 4th Circuit in Sardis v. Overhead Door Corp cited it favorably and noted that the amendment echoes existing law and confirms the indispensable nature of the district court's gatekeeping rule. And then in 2022, still prior to adoption of the 2023 amendment, the 9th Circuit also cited the rule. So you should take a look at that. Okay. Then the other thing that's in this handout, I looked up on Westlaw for you. At last night, so it's totally current, or maybe 2 nights ago. There are 10 citing references here. All of the cases that have cited Rule 702 in the Supreme Court and the 9th Circuit, since we're in the 9th, since January 1st, 2024. There's only 10. So obviously, as we mentioned, this is a very evolving area of law. But those 10 cases, I haven't read them all, but I'm sure we'll all be reading them together soon. Not together, but all of us will be reading them soon. Okay, so expert testimony is no longer presumptively admissible. And then each element of Rule 702 must be satisfied on its own. The expert must be qualified. Their testimony must aid the trier of fact. It must be based on sufficient facts or data. It must be the product of reliable principles and methods. And importantly, it must reflect a reliable application. This is category D of those methods to the facts of the case. And the last one is where in my experience, that's where a lot of experts falter, is applying those methods to the facts of the case. In that handout, I provided some case examples, as we mentioned. In Ray Paraquat, the court excluded an epidemiologist's meta-analysis as unreliable under Rule 702. In Angliza, the Sixth Circuit cited the amendment when excluding a cardiologist who cherry-picked studies. In acetaminophen, ASD, ADHD, multiple causation experts were excluded because they didn't apply their methods reliably to the facts. Practical implications. If you're offering an expert, especially in federal court, you need to come in with a bulletproof record. Lay foundation in your expert report, use language tracking Rule 702, and be ready to argue methodology, not just credentials. If you're opposing an expert, this amendment is your sword. Challenge the reliability of the application, not just the conclusions, but the reliability of that application to the facts of the case. Let's go to the next slide, please. That's the Rule 702 2023 update. We just discussed that. Next slide, please. Yes, here we go. California standards and Sanchez. Oh, sorry, I messed up. Nope, prior slide. My bad. Let's talk about Daubert, Fry, and Rule 702. And let's take a moment to step back and understand how we got here. Expert testimony plays a powerful role in both civil and criminal trials, as we mentioned, and it can explain complex science, economics, medicine, or data in ways a jury or judge couldn't otherwise understand or grasp. I had a case once that involved a retention basin, and like the whole dispute was about the rate of seepage through a cement retention basin in a shopping center. And you know, I learned the hard way that expert testimony has to be really understandable for the jury and the court. I think in federal court, more than ever, we need to make it understandable. We really need to, I mean, experts really sometimes can be in their ivory tower. They're not used to having to explain things in ways that are understandable to lay people. So as practitioners, you know, obviously that's something that the trial lawyer needs to understand how to do. And again, with the court being the gatekeeper, it's more important than ever to understand how to make that understandable to the judge. So how do we know the expert we're hearing from is using real reliable science, or are they just making it up? And that's where these standards come in. The Fry standard was from the Fry case was from 1923, the good old days. Fry v. United States. And this standard came out of the DC Circuit, and it held for a long time. That was the standard for a long time. And that standard was that expert testimony is admissible only if the scientific technique or principle is generally accepted in the relevant field. So it's the general acceptance standard. It's a conservative standard. If the method is new or novel, you might have a tough time in a Fry type jurisdiction. And the focus is entirely on the method, not the expert, and not how they applied it, and not the results. This isn't the standard anymore in California or in federal court in under, the Daubert and Rule 702 standards, but this is how this is where it came from. This is the origin. So the Daubert standard from 1993, Daubert v. Merrill Dow, actually changed everything in federal court in 93. The Supreme Court held that Frye had been superseded and that general acceptance is no longer the only or even the primary test. It's instead the judge has a more active hands-on role as the gatekeeper, even under Daubert, not even counting the more recent amendment to 702. They have to ensure the testimony is both reliable and relevant to the facts of the case, and the court provided a non-exhaustive list of factors to guide that inquiry. Has the theory or technique been tested? Has it been peer-reviewed and published? Is there a known or potential error rate? Has it gained some level of general acceptance in the relevant scientific community? So when you're doing your, expert motions in federal court, it's really important to look not just at the language of Rule 702, but at Daubert, and perhaps even cases, a lot of cases have come down the line from Daubert. It's really important to understand, and we don't have time today to go into the details of it, but it's important for you to understand, really this whole body of case law. So anyways, general acceptance still matters from Frye, but it's just one piece of a larger puzzle. The 2023 amendment to Rule 702 reinforces the Daubert framework in a very explicit way. I was just looking to see if anyone had questions. Feel free to put your questions in the Q&A. I will try to answer them as we go, and I'll try to leave a little time at the end, like 1:25. I'll try to finish by then, so you can ask any questions. So the 2023 amendment to Rule 702 reinforces Daubert in an explicit way, as we discussed. So Daubert isn't just philosophical anymore, it's part of the code. And that's where the Frye-Daubert evolution really ties in under, 702. The method must be reliable, like Frye. The application must also be reliable, like Daubert, and the court is the gatekeeper of all of that. So in short, it's not just academic. The choice of standard can change the outcome of a case, especially when your expert is relying on emerging science or industry-specific models. So let's go to the next slide. Let's talk about California-specific standards. California state courts ordinarily don't do Daubert-type motions. Motions in limine are usually decided, and often decided on the first day of trial in housekeeping. And so, you don't know what's going to happen until you get to trial. And a lot of times, the motion in limine is not going to exclude an expert from testifying at trial. Sometimes it will. I've even seen, it was a long time ago, once I've seen a summary judgment motion granted based on expert opinion. But, that type of thing is very rare in California court. Usually you're in court in front of a jury while you're dealing with the California standards. Usually the battle, like I said, it occurs right in front of the jury. And the most important thing actually that happened in 2016, and it was basically a 10 on the Richter scale for those of us doing things like construction defect litigation, and other technical types of matters. I had been practicing since 2004, or I have been practicing since 2004. So in 2016, I was already pretty set in my ways. I had learned, from my mentors, how to do trial and what's admissible, what's not admissible. I even had, by then, experts that I, typically relied on in certain cases, especially in construction cases, which tend to be very expert specific. And when Sanchez came down, I called them up and we had a chat, and their minds were blown. They couldn't believe it. And one of the experts, I won't say who it was, said, "You wouldn't believe it, Eve. We actually got excluded just like recently in court as a result of Sanchez." And I couldn't believe it. I'd never heard of it before. My guy got on the stand and was ready to testify, And it was objection, hearsay, objection, hearsay, objection, hearsay, sustain, sustain, sustain. That was it. The expert was very well prepared, but had nothing to talk about. And that was, that was back shortly after the Sanchez opinion came down, and that judge had been, kudos to that trial lawyer who had properly briefed the judge on what Sanchez meant, which we'll get into in a minute, and prevailed at trial as a result of understanding how this case-specific hearsay thing works. So when I say it was a 10 on the Richter scale, those of us listening who were practicing at the time probably share my recollection that it was really a big deal. And we had to try to understand it, and we still are trying to understand it. So the key issue is whether hearsay in Sanchez is whether hearsay cited by an expert is case specific. By the way, this case also underscores the broad applicability of this topic that we were talking about earlier, because Sanchez was a criminal case. It had to do with gang crimes, and an enhanced sentence for specific things, for gang affiliation in a violent crime. But Sanchez rocked the world in the civil litigation world as well. So really, these are things that span all different practice areas. So before Sanchez, California Evidence Code sections 801 and 802 were interpreted to allow experts to disclose to the jury hearsay evidence that supported their opinions, even if that evidence wouldn't have been independently admissible. And many people, me included, thought that was unfair. It was frustrating. You can just get this hearsay in the back door or the side door because the expert heard it. How does that make it, fair to present that hearsay evidence to the jury? Seems prejudicial. We were all used to hearing, hey, this isn't offered for the truth. It's just to help the jury to understand how the expert formed their opinion. But, jurors are human. As courts later admitted, jurors were treating those hearsay statements as true and using them to decide critical issues. So in effect, experts were walking in the front door with their opinions and smuggling hearsay evidence in, through the back. So enter Sanchez. Sanchez shuts that door. In that case, a gang expert testified about police reports, out-of-court statements, and gang database entries, none of which were independently admitted into evidence. The Supreme Court said that's hearsay, that's a problem. So when any expert relates to the jury, a key quote from that case at page 686 of that case. When any expert relates to the jury case-specific out-of-court statements and treats the content of those statements as true, the statements are hearsay and not admissible. So the result was Mr. Sanchez's gang enhancement was reversed. So the rule post-Sanchez, now in California, if it's general background information, it's fine. Experts can talk about learned treatises, foundational science, published research, things generally accepted in their field. I've even seen a post-Sanchez case where, unlike the gang database, which was hearsay, a court found that, and you should be able to see that in my references, a court found that a database of drugs that had been compiled through scientific, testing and methodology was general background information that wasn't case specific hearsay. So it's not just every database is not admissible. A database based on community discussions about who's in a gang and who's not in a gang, that's hearsay. Database based on scientific compilation of information, background information, that is fine to rely upon. So there can be a very fine distinction. Case-specific facts must be independently admissible, or the expert cannot disclose them to the jury on direct examination. It's not enough that the expert relied on it. You have to get hearsay in through an exception via a stipulation, or make it not hearsay. Have someone come into court and testify as to the facts. Otherwise, it's out, and so is your expert. And the old limiting instruction strategy is dead. The court made it clear in Sanchez, no amount of judicial gymnastics or dance moves can cure the prejudice. Practical examples. Let's say your expert wants to discuss a doctor's diagnosis from a medical record, a crash report from a responding officer, a witness's out of court statement from a declaration, financial analysis based on bank statements. Unless that underlying information is admitted into evidence through an exception, your expert cannot say it out loud and they can't base their opinion on it. So let's talk about Sanchez in discovery and case prep for a moment. It's no longer something that you can fix at trial. So it requires identifying case specific facts early in your case, tracking admissibility of each layer of hearsay. There can be multiple layers of hearsay that needs to independently be admitted before the expert can opine and use that for their opinion. Get those depositions to lock in foundational testimony, so that if you're doing, pretrial motions, you can reference the testimony in the deposition on which that expert is relying. Business records, and so that you can make sure the testimony, especially if it's an unfriendly witness, that testimony is coming into evidence. Business records exceptions, always something important to consider. Thoughtful stipulations where appropriate. But if you understand Sanchez and you have properly prepared your case and the other side hasn't, and they want you to stipulate to waive Sanchez, don't do it. Make them put their case on properly. Why? Well, because it helps you win, yeah, but also because you're doing your job as an ethical and professional lawyer, making sure that junk science isn't getting into the case and that the trier of fact is being properly advised and your client's not being unfairly prejudiced by unreliable expert opinion. If your expert, bottom line, if your expert plans to rely on it, make sure it's admissible. Let's look at the next slide. Common admissibility challenges. Lack of proper qualifications. Let's say your case involves mold damage to a commercial property. You hire a contractor with expertise and experience in mold remediation, but no formal environmental science background. If your opponent moves to exclude it, they might succeed, especially if the court finds the expert lacks the qualifications to interpret test results or give causation opinions. So make sure your expert has the right academic, licensure, and professional background specifically tied to the issue at hand. A general, well, I've seen this before, isn't necessarily going to cut it. And when we talk about ethics a little bit later in the program, in a few minutes, I'm going to share with you what I find to be, for me, a helpful way to vet experts early in the case. It helps not only with admissibility, but making sure that you really are adhering to ethical standards when you're picking experts and preparing them. Improper methodology. If your expert does biomechanical calculations to determine how your client's spine was injured in a low-speed collision, but they don't provide error rates or peer-reviewed sources, and the technique isn't widely accepted in the field, that's a dauber or admissibility landmine. So if a little practice tip, you don't just need the right method, you need it applied in a consistent, documented, and peer-reviewed way. Inadequate foundation. If an engineer bases their opinion about structural failure on a visual inspection, but they don't review the blueprints or conduct testing or gather load data, and the opposing side challenges the foundation, they could very well win on that. So practice tip, always ask, what does the expert know and how do they know it? How do they know it, right? A missing link in the factual chain is grounds for exclusion. You have to have a very clear, admissible chain of underlying facts. Relevance or hearsay problems. Your expert relies on a treating physician's comment from an unadmitted medical record. For instance, this was clearly caused by the prior surgery. The doctor notes that in their notes. That's hearsay unless you admit the record or depose the doctor and have the doctor testify. Your expert can't rely on it and can't say it. So if a case-specific fact is critical to your expert's opinion, make sure it's independently admissible or your expert cannot testify to it. I can't underscore, having lived through both the old days, pre-Sanchez, and really pre-Rule 702 changes, and sort of how things have evolved, having personally lived through it, it is a sea change in our industry about, or in our practice about, what experts are allowed to do. I started the first 2 years of my career, I did just construction defect litigation in the heyday of that residential. I don't do residential anymore. Don't call me for residential. But that first 2 years we did, and I did a ton of expert stuff as a young associate. That was like what I was tasked with handling. And those experts, it was so loosey-goosey in California state court about what they could opine on, what they could bring in, what they could say. And then when Sanchez hit, I mean, everything has really changed. And I think it's for the better. Personally, I think it's for the better for the reasons we talked about. We don't want junk science in our courts. We want everyone providing reliable expert witness testimony. And we don't want, we don't want the jury to be bamboozled with inadmissible hearsay in the guise of, oh, well, the expert relied on it. So I personally think these are good changes, and I think they make us better lawyers and they make our system of justice better. Okay, let's go to slide 9. Mitigating risks. This is what I was talking about before. Vet your experts early. Get that expert on the phone when you get the case and you realize I'm going to need a valuation expert. I'm going to need a damages expert. I'm going to need an expert on, spinal robotics. Get them on the phone and, vet multiple experts, unless of course, you've got certain experts that you regularly use because you just know that they're reliable and they do a good job. That's different. But, you might want to vet just multiple different experts and see what different people are saying so that you as the lawyer can get multiple different opinions and understand who really has a reliable opinion here. And how am I going to do this case, right? This comes down to ethics that we'll talk about later too. Am I going to do ABC in the case, or am I going to go this way, XYZ? A lot of times, what your expert has to say shapes what you're going to do in the case. It shapes the kind of discovery you're going to conduct. A lot of times it shapes whether you feel inclined to settle early and advise your client that, you have some really tough hurdles in this case. Or are you going to fight hard, go to the mat, and feel confident about going to trial? And when you get to trial and you've vetted your expert early and you've worked with them throughout the case, you don't have to have those surprises. No, but one cardinal rule of trial work, you don't want any surprises at trial. I know all the trial lawyers that, regularly do trials are raising your hands in agreement, right? No surprises at trial, unless you're surprising the other side. But you don't want to be surprised. And so vet those experts early, review their methodology and ensure it fits the case. We have better research tools as lawyers, as lay people, to vet research than ever. I mean, it's not just the internet anymore. We have AI research capabilities through Westlaw that are, really state of the art. We have all kinds of ways to do research and vet those experts. And, again, make sure you don't have any surprises later. Anticipate Daubert and Sanchez objections. Talk with your colleagues about it on the case. Talk with the expert about it. What could be objectionable? Put yourself in the other guy's shoes, the other lawyer's shoes, and say, if I were them, what would I be objecting to? Consider mock testimony to stress test the expert, especially if it's an expert you haven't used before. Then do it before you have to disclose experts. If this is someone that's just not going to be able to properly explain things and get that methodology and its application to the facts of the case across to the judge and the trier of fact, Wonderful. Make them a consulting expert and find someone who understands how to explain it in court. Rely on scientific method. I was a hard science major. I was a biology major at USC, fight on. And I learned scientific method, obviously, as a science major. Not all lawyers, a lot of lawyers are much better than I will ever be at things like economics and history, so on and so forth. So we all have our areas that we kind of grew up in. And not everyone really got a great grasp on scientific method in their, school days. It's not that hard to learn. So if you haven't ever like really delved into scientific method, I'm telling you, it can really be a game changer. And I have used it as a game changer in the area of expert testimony. So if you go do homework after this on anything, just Google scientific method if you're not familiar with it. Many people probably are, and maybe, but it's just a huge help. And I'll get into it a little bit more in a couple of slides. But let's talk about strategy. Whether you're trying to get your expert in or keep the other side's expert opinion out, this is one of the most persuasive tools you can use, scientific method. And the reason it's so persuasive and helpful is because courts love structure. Judges love reliability, and scientific method is by design a repeatable, logical, evidence-based process. Okay, it starts with the foundation that the truth of the matter is we can never know anything for sure. That's kind of counterintuitive, isn't it? We're trying to find a method that helps us to explain why our opinion is right. We're starting with the foundation that we can never know anything for sure, for certain. But that's the reality. We can't know anything for sure. Descartes might disagree. He would say, I know that I exist because I can think, right? But really, that is just a theory. I think, therefore I exist. It's a theory. Okay. So it was, and if you go through the whole process of getting to that through Cartesian theory, you'll see he started with, and I don't want to get too deep into the philosophy here. I won't, I promise. But he starts with, he starts with testing some hypotheses, right? He forms a hypothesis. In fact, he forms a null hypothesis, which is, I'm going to prove the opposite of what I think is true. And if I can't prove it, then I'm supporting my true hypothesis and transitioning it into a theory. Okay, so scientific method is how we go about that. If you can explain the steps of going from a hypothesis and testing it either as a null hypothesis or through accepted methods of computer modeling or whatever it is, and then you get to a point where you've reliably supported that hypothesis, it becomes a theory. And that is something that your expert, that theory of the case, the theory of causation, the damages theory, those are all expert opinions that are then admissible in court. Quick, like whatever Cliff Note version on that method, you ask a question or identify a problem, you form a hypothesis, you gather data, you test the hypothesis using consistent accepted methodology, you analyze the results, and then you draw a conclusion that can be replicated or peer-reviewed. Not you, but your expert. And sometimes experts aren't familiar with that, and in my experience, they welcome you offering them that structure or walking through those steps. It gives them a feeling of confidence as well. It's really almost magical. Let's see. Here's an example. Your environmental expert tests multiple soil samples, runs them through an industry standard protocol, shows their results with reference to published EPA guidelines, and explains why the presence of toxins rules out a natural cause. That's good science, and a judge will recognize it as such. You can also use it to exclude your opposing expert opinions if they can't stand up to the rigors. Flip it. You can use the absence of a scientific method to exclude your opponent's expert. Did they form a hypothesis or did they start with a conclusion? Did they test alternative theories or ignore contradictory data? Remember the cherry-picked case that we referenced earlier? Ignoring contrary data is a big pitfall. Did they use published acceptable methods or did they just invent their own? And did they replicate their process, or could it be replicated? Could they explain how it might be replicated, or are they just winging it from experience? These are all ways to flesh out junk science that somebody else is offering that you'd like to exclude. If they don't, bottom line, if they don't follow a repeatable logical method, whether it's scientific method or some other repeatable, acceptable logical method, you have a basis to challenge that expert opinion. Here's another example. The opposing biomechanics expert says your client couldn't have been injured in a low-speed impact, but they didn't test vehicle damage. They didn't calculate force vectors. They didn't consult peer-reviewed research. They just eyeballed it. That's not science. That is speculation, and you should be able to exclude that. Here's a little pro tip. Speaking the court's language, right? Here's some phrases that you could use. This expert's opinion is not the result of scientific method or reliable application of methodology as required by Rule 702, Your Honor. Whether you're defending or attacking an expert, that phrase, this expert's opinion is not the result of scientific method or reliable application of methodology as required by the rules. Whether you're defending or attacking an expert, that phrase frames the court's gatekeeping duty, and it signals that you understand the rules and that you're following them to the court. That's very helpful. Okay, let's go to the next slide. Examination strategies. Oh, here's a question before we get there. Can the state of mind exemption allow case-specific hearsay? For example, appraisers rely on comparable data from specific transactions to inform their value opinions. This is recognized methodology, but case-specific comps inform their own state of mind regarding their own value opinions. Could the state of mind exemption allow the admissibility of the comps? Okay, so I think what you're asking is whether comparable data is a hearsay problem for experts, maybe under Sanchez. This isn't my particular field, but we use comps too in real estate all the time. And I haven't had any trouble getting comps admitted. So the comps come from a database. Okay, now it's not like a gang database. It's also not a medical database. So the gang affiliation database is Sanchez. That's excluded. That's hearsay. Later cases have said things like medical information in a database is reliable. It's hearsay, but it's not case specific hearsay. Those comps are hearsay, but they're not case specific hearsay. They're in a database of information. So I would argue that just like real estate comps, these sound like similar comps from a database. If it's, so you're asking about specific transactions, comparable data from specific transactions. I think you're so if it's from a database that is, based on reliable information, I think you don't have a Sanchez problem. But if you want to chat more about it, I'd be happy to delve into it a little more if you want to email me. I think it's a fascinating question, and happy to dive into it a little bit more. Or if anyone else, if anyone else has input as to that question, I'll be happy to read it in the Q&A and repeat it to the group. Okay, let's talk. The next slide was examination strategies. Again, feel free to put your questions in there. I'm happy to answer them. And I've built in time to do that. I think we have 12 slides, so we're getting pretty close to the end of the slides, although I wouldn't mind going through some of the 702 notes as well if we have extra time. So, but totally up to you. Okay, examination strategies for experts. Okay, someone says, my comps are Cedar Beauchamp. Thank you, Francisco Sanchez, for your question. That was an interesting question. Cedar Beauchamp says, my comps are often confidential and cannot submit them as evidence. If you can't submit your comps as evidence, I don't care if you're in federal court or state court, you are not going to be able to get an expert opinion based on inadmissible evidence. That is absolutely clear. So I'm not sure what you would do about that. So that is an interesting situation. You didn't mention your area of practice, but okay, examination strategies. On direct, you want to tell a cohesive story. You want to build the expert's credibility. And you want to emphasize the already admitted evidence as you walk through how they form their opinion and what their opinion is. So you want to just go step by step through the method they used. Okay. And just one piece at a time. And you want to make sure at this point in the trial, when you're on direct, that you've gotten all the evidence in that that expert's going to rely on. Right. Sometimes judges are nice enough to let you recall witnesses or, see if you can get some evidentiary evidence in. Don't forget, as you're going through fact witnesses, get those exhibits in. What are just the most basic things, right? Just making sure you got it in evidence. And that by the time your expert is testifying, the jury, the finder of fact, if it's the court, is really familiar with those key pieces of evidence that are going to, it's like building a wall. You're building a brick wall and your expert sits on top of that wall. You want to build a nice strong wall. MLS comps, highly reliable due to realty board rules. Warren, this is a comment by Warren Worth. Thank you, Warren. By the way, if you don't want me to say your name, when you do the comment, just say, please don't say my name and I won't. Otherwise, I'm going to say who the question was from. Warren Worth. MLS comps, highly reliable due to the realty board rules, right? Agents' duty to provide accurate info promptly and also use by almost all brokers. 100% agree with you. I have not had any trouble there. I haven't found a single judge that has felt like MLS comps are out of are inadmissible hearsay. They, in terms of what an expert can rely on. This is the kind of non-case specific hearsay database that experts can rely on. And again, see, it can be a very fine call. And I think state court judges tend to be more reluctant to exclude than federal court judges, but Sanchez does help to get some of that inadmissible hearsay, keep it out. Okay, cross-examine, we talked about direct and kind of how to build that wall. Your expert sits on the wall. You want to make sure you've got, everything in place before you're calling your expert to testify. Cross-examination. The goal on cross-examination of an opposing expert is to expose bias, assumptions, improper assumptions, and flaws. So some people disagree with me. I think that trials are won and lost based on cross-examination, not just of experts, but fact witnesses. And it's really your opportunity to shine as a litigator and to show your preparation because you are thinking on your feet. Again, never to be replaced by a machine as far as, well, never say never, but you're not attacking the person. I think the most effective expert cross-examination is very, very cordial and professional. And you're just dissecting that opinion based on all of the different factors that apply. Methodology, application to the facts. How did they get through? What are the missing links in the chain? That's really the fun part. I think that's the fun part of dealing with expert testimony. 3 attack zones. Bias. Is this a career expert who always testifies on one side or the other? Have they testified in 40 asbestos cases and never found in favor of a defendant? Have they, so kind of in line with that, this happens, frequently, I would say not frequently, but from time to time, the expert has given the opposite opinion in a different case where they have published a treatise or an article that says the opposite of what they're saying. I mean, that kind of goes, I think, hand in hand with bias. I'm not sure what you'd call it, but just self-contradictory. Unsupported assumptions. So what assumptions underlie this expert's opinion? Did they assume that their client was going 60 miles per hour when the data says 25? Well, that's going to change the opinion, right? So you want to expose that. Flawed methodology. Did they fail to test alternative theories? Did they rely on a method that lacks peer review? Did they cherry pick their data? So use tight, closed-ended questions. Here's some examples. That fact came from a hearsay police report, correct? Came from this police report, which is hearsay. Okay, you didn't review the treating doctor's deposition before forming your opinion, did you? You didn't read that deposition. You haven't published on this subject in 15 years, right? So the goal is to create some doubt, again, without sounding disrespectful, and let the jury fill in the gaps. On redirect, rebuild and clarify after cross. If your expert took some hits on cross, don't waste your redirect. And make sure that you address everything. You'd be surprised what stands out in, the jurors or the judge's mind. It might be different. So take copious notes and make sure you cover everything. 3 cardinal rules: only address what was raised on cross. Reinforce the expert's process. Let's go back, you're on redirect. Let's go back to the data you used. What was your source? Clarify any misleading impressions. If opposing counsel put words in their mouth, twisted an answer, walk it back with dignity, walk it back. You take your time and make sure you cover that base. And sometimes that redirect can reinforce your expert's opinion even more than what you were able to do on direct. So clean redirect can really be very powerful. Here's a practical illustration. This expert has investigated over 100 construction failures, including subsidence under shopping centers, exactly like this one. She applied a soil compaction model peer-reviewed in the Journal of Geotechnical Engineering. Here's how she reached her conclusion. Cross, you didn't test the site personally, did you? You relied entirely on the report of a subcontractor, right? And that subcontractor wasn't deposed in this case, correct? On redirect, you might say, can you explain why that subcontractor's report was standard in the field and why it was reliable in your analysis? Of course, at this point, you might have a real Sanchez problem, depending. Let's go to the next slide, please. Practical tips: collaborate with your expert from the beginning. Don't wait until trial to think about admissibility, and understand both the law and the courtroom dynamic. Enough said. Let's go to slide 13. I am down to the last few minutes. Are there any questions before I get to the next slides? Or I will just finish up with the next 2 slides and we'll be done. Okay, ask now or forever hold your peace. Let's just take a quick detour into ethics. Number 1, no contingency fees for experts. You cannot pay a testifying expert a contingency fee. They must be independent sources of analysis. Number 2, don't coach the conclusion. You can prepare your expert for direct and cross. You can help them understand Rule 702 or Sanchez, but you cannot tell them what to say or edit their opinions to fit your narrative. Again, back to the original, start early, find out early. Don't be like, here's another bonus question. I have 2 minutes. Don't be like Cinderella's stepsisters trying to shove that big foot into a shoe that doesn't fit, right? Start early and make sure the shoe fits. Here's the bonus question. In the original Grimm's fairy tale, Cinderella's slipper was not made of glass. If you can tell me what the original material for her slipper was, I will buy you a coffee at Starbucks here at Watt Plaza. First person. Original Grimm's fairy tale material of Cinderella's shoe. A third thing about ethics with experts. Consulting versus testifying experts, very important to understand. You do not have to disclose what your consulting expert and you discuss. That's work product. It's sometimes privileged. You don't have to disclose that unless and until you disclose them as your testifying expert, and then everything you've discussed with them is fair game, even if your client was copied. So if you want to have private conversations with expert consultants that you feel like what you've discussed with them isn't helpful for your case, and you don't want to use that, and you don't want to disclose it, do not designate them as an expert, as your testifying expert. Okay. Emerging trends. Can we see the next slide, please? Nobody knows the original Cinderella slipper material. I'll tell you before I get cut off, which happens in like 60 seconds. It was feathers, not glass, feathers. Okay, emerging trends. Increased use of animations, simulations, and virtual reconstructions. Using a lot of really great technology. So something you want to look into, and I might say it can be very helpful not only at trial, but also at mediation to present your expert testimony in a really interesting and dynamic way. So I'll just leave you with that. I wanted to say thank you so much for letting me present on this topic. I wish you all a wonderful rest of your day. It is 1:30 and I see no more questions. So thank you. And if you want a cup of coffee, email me, hit me up, and we'll make that happen. Thank you.